Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cintron. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cintron.
Hi, everybody, and welcome to the Third Fridays podcast. That's right. I took a little pause because it's been a while. It's been a couple months. I can't remember the last time I took a month off without an episode. So thank you to those of you who emailed me asking where I was. Very kind of you and showing me that I'm not doing this for sport. It's been a great couple months. I'm a new dad. And life couldn't be worse. No, I'm just kidding. Yeah, life is great. Super happy and grateful and positive for everything that's happening. But I actually couldn't wait to get back and record one of these thingies. And today I want to welcome one of our top associates in the firm, Alexa Cintron. Welcome to the show.
Hello, happy to be here.
So when I talked to you about this episode, right? Now, sometimes I have a tendency to not be clear when I have this like crazy idea, right? Like, what were your thoughts? Like, without even telling the listeners what the episode's about just now. Although I guess when they click on it, they'll see like the prompt, right? But like, what were your thoughts when I talked to you about what we could do today?
I thought it was extremely interesting because, you know, the whole idea of April Fool's Day and tricking people, being gullible. I feel like in our line of work, a lot of the way the law is written sometimes can be very, wait, really? Is that how it's going to pan out? Is that actually the rule? How is it interpreted in court? I feel like there's a lot of gray area in workers' comp law. So I feel tricks and being gullible kind of play into that.
Yeah, I think that, I mean, the idea of presenting a premise and then asking your compatriot, like, is this real, right? We experience that so many times where, you know, for the listeners who are in the industry, right? They're risk professionals, they're, running finance in employers, they're insurance adjusters, they're claimants attorneys, right? Other carriers attorneys, right? It seems like sometimes a thing happens and you're just scratching your head as to why it happens, because we lose this idea of common sense sometimes when we're either sticking to a rule too much or maybe creating a new rule or a rule of law that isn't approved by the legislature, something like that. And for me, I don't know how about you, but in my personal life, I feel I am more gullible than the average individual, right? Like, I am the person who, if someone said like, do you know that like the word gullible is not in the dictionary? I'd be like, what? Really? Like
You're one of those.
I fell for that trick. Like, I was like, what? I guess I'm too trusting in my personal life, or maybe I think that I'm just not trustworthy, or I don't trust claimants at all so much
that you need to question it. I
need to like have some sense of humanity in my outside world.
Yeah.
You don't strike me as someone that is gullible.
No, I'm pretty matter of fact. It depends. It really, a classic lawyer answer, it depends. On April Fool's Day itself, I don't fall for anything. Like, if I know it's April 1st on the calendar, if you tell me anything, I'm looking at you like, are you sure? I don't believe. I'm not going to usually fall for it if it's April Fool's Day. Right. Any other day of the week, probably depends on the person who's talking to me. If they're like a trusted friend, like if you were to come in and tell me like a crazy story, I'd probably believe you until I didn't anymore. And I was like,
you like, what? Give me a chance to like make it right. Yeah, I mean, I should be like that, I think, but I'm not. Like, on April Fool's Day this year, right, we had some of our family come over to visit the baby, and just in a text group, they said, we're bringing like 5 more people over couldn't say no. So, we'll be there in like 20 minutes or something. And when I read that text, I was like, what? I had I started drafting something, and then I started sending a separate text to my wife, like, well, what's going on here? And then it was my wife who responded in the group text saying like, okay, April Fool's hot. I was like, oh, right. That's me again. Right. Like I will believe these things. But I think from a defense perspective, you can't be trustworthy or you can't be trusting of the other side, because I think the way it's set up is that you will be fooled. You will be hurt.
Right.
If you trust the claimant. So this premise that we thought up today was we'd create three types of scenarios or headlines that could potentially be real or not real. And then the other person would decide like, okay, no, that's like an April Fool's joke, right? Like we're past April 1st, but like, the idea is that like we see these things so often, this is what we live with, right? So why don't you start first?
Okay.
And then I'll try to think of what is real and not in your premise.
Okay. All right. Mine, this first topic, it's not more so of a scenario, but I'm just going to tell you a statement.
Okay.
And you kind of loop it in and tell me how you think this sounds in the workers' comp context.
Love it.
So we have an injured worker who remains an employee of the insured employer. So continued employment with the employer is sufficient in and of itself to establish attachment to the labor market.
Okay. Sometimes like I think of like my test taking skills in this, where it's like, if like, they tell you that if it's too much to the extreme, it's got to be like wrong no matter what. But since I know the answer to this question, or I mean, might be getting into hell. What if I get this wrong? Right? No. When this podcast is over, like it's ended. This is the last episode if I get it wrong. No, it is not sufficient. That's an April Fool's joke. Like just because you're employed with the employer doesn't mean that you are attached to the labor market.
Correct. That is an April Fool's joke.
Wow. Yeah. It was like actually beads of sweat on my forehead.
Get it wrong.
So I think what you're going for is the premise of active employment versus just employment, right?
Yes.
So like what is the difference?
Right. So building off of the topic that I just stated, so mere continued employment with the employer of record is not sufficient in and of itself to establish attachment to the labor market. The injured worker needs to still show an active employment relationship with that employer. In my practice, I've seen that be able to be done in a few different ways. It could be as simple as, the claimant proving that their employer is still carrying their health insurance. It could come down to, I think what the judges really focus on and what the parties really try and push is the intent of the claimant to go back to work if
and
able.
The employer.
Yes, right? And the employer. They want him back to work. They've had conversations about it. I think that would be, the easiest way to prove such a relationship. I talk to this person once I'm done with surgery, once I'm done with physical therapy, I do want to go back. Right. But without that, there's the carriers have a strong argument to prove no attachment.
And that's an important distinction because it seems obvious, right? Like, maybe even getting to, I know this is supposed to be a 201 level of conversation, but like to someone who doesn't even know what labor market attachment is, right? Like you have to essentially mitigate the carrier's responsibility to pay you wage replacement benefits by showing that if you have an ability to work, you're trying to still look for work. You're trying to remain part of the labor force. You're not just completely extricated from society in the workforce as, just a matter of speaking. But claimants all the time, right, will say, I'm employed, right? So your premise is, that would be sufficient. And that's why it's an April Fool's joke, because it has to remain active. And so something like you mentioned, carrying health insurance, that seems way more active than what many employers don't even really do, right? Because the employer is now taking on a cost
Sure.
every period.
Sure.
because they're expecting
that
the
person
person
will
comes
come
back.
Yeah. And then I had an interesting scenario in the same case. I litigated this issue twice. We lost the first time because the claimant produced a letter showing that she was an active employee. So the judge upheld that. Came back a few months later on the same issue because the letter didn't seem like enough. It was just very boilerplate language.
Right.
So we asked for more testimony on the issue. And what ended up happening was the claimant conceded to the judge that I got this letter off of an automated HR website. I didn't actually speak with anybody. I don't know what my current job duties are. I don't know who my current supervisor would be if I did return. So fleshing that out a little further with the judge, even though there was a clear letter that showed that this woman was an active employee with the company, there was no intent on her behalf to return to the employer. So the judge found that there was no active employment relationship and that she voluntarily removed herself.
That's actually a very interesting subplot because I think it goes to what I see a lot in claims that come to our firm, in the middle of litigation, right? Handled by someone else, or maybe not having counsel at all. Sometimes it seems like attachment is attempted and that's like the one time, right? Mm-hmm. And so when you lose that first time, right, having the idea to say, okay, this is an ongoing duty, right? I'm not sure you get that concession from the claimant if you're not continuing to pursue attachment again.
Of course, if realistically, that's why the issue needs to continue to be pushed. I do feel like there's some scenarios, like you said, when you inherit files or you're looking at a file that you didn't have from the beginning. Why was labor market only addressed once and the person continues to be out of work? So just really digging into the file deep and seeing, well, what else can we do? Because we have the right. It is an ongoing obligation. We have the right to continue litigating it. Now, sometimes we get pushback when we're bringing it back to court.
Oh, sure. Judges love it,
they're like, why are you here again?
Didn't we already do this?
Yeah. Weren't you here 2 months ago? Well, judge, it's an ongoing obligation. And if our client continues to pay benefits, we have the right to investigate it. So I was happy in the case I just mentioned that we brought it back and got a good result.
I think also, and really, you do a whole podcast episode on this issue itself. I think active employment is so fascinating to me because most times when they can prove employment as the reason to not having to look for work or undergo vocational rehabilitation or attend a full-time school accredited, a full-time accredited educational institution, it's almost like their implication is, well, the employer hasn't fired me. Right. Like they haven't received that termination letter. They haven't gotten that email from someone in the company saying, hey, we're moving on from you. Mm-hmm. Right. So they believe that they're employed, meaning that they don't have to. And really, that's the significance of the intent argument. Mm-hmm. Not that people talk so much about active employment as, needing like a mens rea with it.
Right.
Like the difference is that a lot of claimants believe that just because I haven't been fired doesn't mean that I have to look for work,
Exactly. And I feel like in my mind, it's really, if you did have a true goal or intent to go back to work after you were injured, you would likely be having some form of communication with your employer about that process is how I would imagine you would handle the situation. So this area of law that we can establish, especially the active employment route as versus to, a labor market attachment work search when they're not employed any longer, I think is a great resource for us.
Right. Okay. So, all right. That was an April Fool's premise. I'll go next. So in my premise, a claimant has sustained a work accident in January of 1995. Okay. And then 6 months later, he testifies under oath that he's unable to work in any capacity. The employer produced evidence that he was working for a new employer through a social media search. and they argued that Section 114A should apply to bar awards for life. Like, hey, here's my social media investigation, right? I guess in 1995, what social media was there? Like Zanga or some blog?
AIM?
Yeah.
Not
Oh
even
my God.
AOL?
Right? Away messages. Like
Literally my away message.
right. The away message is working.
Oh my God, maybe.
Right? I just thought of that now. Okay.
It's funny.
The judge, in response to that argument from the employer, says, I've never heard of such a thing. And I reject your argument. Is that an April Fool's joke?
I've never heard of such a thing. I've never heard of using social media
I've never
as a
heard
basis for a 114A finding for mandatory penalties.
I've never heard of Section 114A.
Oh. I'm going to say that's an... Ooh, I might get this wrong. I'm going to say that's an April Fool's joke.
Okay.
Fraud.
It's very tricky.
Yeah, wait.
Because the premise of it is it's the most clear evidence of fraud, right?
Right.
That you say you're not working, but you actually are.
Right.
Right. So you're getting you're getting resources and payment and income, wages from someone else, but then saying I'm not doing that, so you pay me wage replacement benefits, right? So you're getting this double recovery, even though that's not necessarily required to prove fraud, right? The judge says I've never heard of that, right? And so the idea that a judge would never hear of a statute obviously seems like an April Fool's joke, but the reason why it's not April Fool's joke is because the fraud statute was only enacted in 1996.
Okay, that's where I figured you were going.
Happy 30-year anniversary to the fraud statute.
Wow. That's
1996. Like you were a baby.
Yeah, I was 2 years old.
Yeah.
I was 2 years old. Okay. I don't know if I knew that.
Yeah.
I feel like, so there was no fraud in workers' compensation before 96?
I would have to imagine that, obviously, not to completely age myself, but obviously I was not even in high school at the time, but the idea that you present some false testimony can probably lead to a credibility argument.
That's what I was going to say. Maybe it was more so you're not credible.
Right. Or maybe your doctors,
you're not going to get these awards.
Your doctors don't have the right information. So maybe we'll rely on the carrier's IME or the carrier's fact witnesses. But the actual fraud statute, 114A, was not enacted until 1996, which had the mandatory and discretionary penalties. So I would imagine even if that were to be used by the carrier and say he's not credible, there would be no idea of a permanent...
Right, there would never be a thought of that.
Right? So imagine a 1995 claimant just commits the most egregious fraud ever and then also says, I'm sorry. Oh.
Yeah.
They probably don't even need to apologize.
Sure.
Right? And then they get this back. And so for only 30 years, employers have been able to use this defense that seems so very obvious.
So obvious. Wow, I learned something new. That's very interesting.
But to be fair to you, in that I knew that it wasn't around for a while. I did look it up to find out exactly when it was enacted. It came out.
That probably had I wonder if you could look back and see in that year and the 2 years following the enactment of that statute, how many times fraud was raised by a carrier.
You're going to put me down a rabbit hole because we could go to Westlaw and search fraud from 96 to 98, right? And see how it was truly litigated. But what's interesting when I was doing this research is, how Westlaw will have practice commentaries, right? Shout out Westlaw, right?
Shout out Westlaw.
All the cases that are cited by Westlaw to help you understand how to apply it in real life are from I think the oldest one I saw was 2013. So I guess in a way that would have happened no matter what, because case law will update and differentiate as facts become different or the years go by. But it is very interesting to put ourselves in the shoes of attorneys 31 years ago.
Yeah.
Not have this weapon, not have this tool.
Right. Because I also feel like it was probably raised a lot after enactment, obviously, but I wonder if the judges got on board with it, really.
Yeah.
To be all right, we'll do development of the record, or if they were no, it's too, maybe they shrugged it off.
Right.
Because that even happens today.
Absolutely.
That happens today. There's been countless times I've raised the issue and I'm not even allowed development of the record.
Oh yeah. Right.
So I'm wondering how back then, once it was a fresh statute, if judges similarly were like, I'm not doing this.
Right. What are you talking about? Yeah.
No.
Yeah. Actually, I could have probably changed the year to like 1999.
Yeah. And I still probably, that's funny.
We certainly have cases in our office where a judge won't develop a record on fraud.
Yeah.
Right. Like now in 2026.
I have one on appeal right now.
There you go.
now.
Right. It's like I'm just trying to get a trial. I'm not even asking.
I'm not even asking for I didn't ask for anything yet.
Yeah. It's
That's funny.
It is what it is. Okay. So, all right. So, that was mine. Now let's go back to you for one.
Okay. So we've had 2 April Fool's jokes so far. Okay. My second is if the claimant if we're at permanency and there's a permanency trial and the claimant is classified with a loss of wage earning capacity at the permanency trial, receives a permanent partial disability award, and is also found unattached to the labor market at that same hearing, then the claimant remains obligated to produce evidence of labor market attachment.
Okay. Couple clues you gave me, right? One was starting it off by saying we had 2 April Fool's jokes. So I was like, okay, she's going to give me something that's accurate.
Or something
right?
in there.
And I also just started smiling as you said it because who promotes themselves less than me, right? Like the self-promotion from my own being is always through the roof. So I almost smiled just because of how proud you must be to get such a great result in this particular issue.
Mm-hmm.
So your premise was there is a continuing obligation.
Yes.
Yes. Okay. So that is not an April Fool's joke. That is correct.
Yes.
Because of the work that you did in your case, about someone who essentially, I guess, differentiates the case from whenever labor market attachment went away,
Mm-hmm.
right? I forget the year offhand, but the board ruled that once you're classified, attachment's done,
Mm-hmm.
right? And employers across the whole state were like, that's an April Fool's joke, right?
Then they were like,
real,
that can't
right?
be
You
true.
can't do that, right? But you found a case, you argued it, and applied it to your trial,
Mm-hmm.
and were successful. Tell me about not just the result. Almost want to backtrack there.
Mm-hmm.
When you find the case,
Mm-hmm.
what was going through your head when you found that case?
Honestly, extremely shocked because, and in a good way, because it gave us a tool when we really thought it was over. This claimant had a really high loss of wage earning capacity award implemented, through the roof exposure for the client. It was bad, and we were just trying to discuss. Settlement wasn't really an option in terms of the numbers that we were dealing with. So the clients were really concerned and just wanted to know, are we really done, or is there something we can do? So when we found the case law that speaks to this notion that they have an ongoing obligation to look for work if they weren't classified, I went back to, the initial decisions, because this case, it was tricky because trying to apply the facts to the situation, because there were a lot of appeals. There were a lot of times where attachment was raised in the past, litigated at different times. But then when we came down to and I looked at the decisions on permanency, I noticed that at the first trial, when he was classified, he was found unattached. Now, he was found attached a few months later, but that didn't, based on this case law, it doesn't matter if they're not. And those initial findings were upheld on appeal, as in at the first hearing, the no attachment to the labor market was upheld. So that was our saving grace there. So when we found this case law, we explained to the client, we were like, listen, we can try and find him. We can put him to his proofs again. We can raise the issue with the judge, and we have this case law supporting it. And he should have that ongoing obligation to look for work. So when we brought it to trial, the trial judge agreed with us.
Did it take some convincing? Or maybe let's step back a little bit. When you first proposed it as an action plan,
Mm-hmm.
what was the client's reaction? Were they like kind of like, whoa, like what?
Yeah, the client was excited, and I think they were a little kind of, are you sure? Like,
Yeah,
is this
like
going
just-
to work?
Right,
And,
right.
you know, as carrier attorneys,
Which is a normal response, by the way.
yeah, 100%. Because honestly, before this case, the longest time we were telling them, like, we might not have any more recourse. We can try and settle, but other than that,
Right.
might have to keep paying his weekly award. So we told them, as in the client, that this should work. There's really, like, our facts align very much so with this case law. So what we'll do is we attach the case law when we requested the hearing, just based on, and usually I don't do that. But in this circumstance, we thought it was smart so that the board honestly didn't ignore our request to bring it for a hearing, and it worked. And when we got there, the judge, he needed a little convincing, but he had the case law in front of him. So he took the time and read the case and was like, yeah, no,
This looks right.
I'm gonna set it down. The claimant's counsel obviously
Freaked out.
had things to say about that. They appealed.
They appealed the decision to set it down.
They appealed the direction to set it down for testimony. So nothing happened. We tried to bring it back. So the judge set it down, 60 days.
Yeah.
We filed at the 60-day mark because I don't remember. He may or may not have been doing the work searches at that time. But in any event, they still appealed. So we brought it back for testimony, and then everything got held because of the appeal.
Oh, so
They
like,
wouldn't-
so the client still had to keep paying.
We kept paying because we didn't really have a basis to suspend pending. But the board panel came back and was like, no, the carrier is correct. This case law is good law.
Right.
He has an ongoing obligation. Opposing counsel did try and make a public policy argument in their appeal.
Why not?
Of
Yeah,
course.
of course.
Try it. Why not? But the board panel agreed with us, and we've at least taken one round of testimony already on the issue.
That's pretty cool.
And we're coming back in a few weeks for more.
What? And tell me if this is kind of looking too far into things, but like hearing it and seeing how it played out, obviously great for employers and carriers that are trying to defend the integrity of employment. Am I right to be concerned, though, that if judges start to see this, we just talked about a case where judges don't want to set the case for trial, right? Like, why are you here again on attachment? Would you be concerned that a judge would be more likely to find attachment at classification, knowing that if they don't, they're going to be back here every 6 months or so under the premise of whether or not this person is attached?
That certainly is a concern, I would say, because even in this scenario, I did get a sense at the first trial back, taking the testimony, that the judge was kind of, I mean, he was found attached at the
Right.
second hearing, because realistically, he was, you know, there's different arguments to make, and it depends on the actual work searches in the file, but this claimant was applying to some of the same lines of jobs that he was applying to when he was found reattached way
Okay.
back.
Okay.
So I feel like if it's the same judge and you're dealing with the same thing over and over again, I do feel like the judges could get a sense of what's happening and start finding them attached at that permanency trial to avoid this.
Yeah.
Again, I think that's obviously where we use our appeals process to help us out there, because if that attachment finding were to get overturned,
Right.
we would have that under our belt again.
Right.
But yeah, no, I would agree that that's something. I do think this rule in the next maybe 10 years is something that's at risk of being brought further by claimants' attorneys. But for now, I'm happy we have it, and it's something that is definitely useful to us.
Yeah. That's great. That's great. Great stuff. Okay. I'll go now. So my next premise is the guidelines for determining permanent impairment and loss of wage earning capacity compensate schedule losses of use and non-schedule losses of use fairly. All industry stakeholders celebrate and have parties in the streets.
That's what you're trying to tell me?
Yeah. Is that real? Is that accurate?
No, that's an April
Yeah, it's an
Fool's
April Fool's
joke.
joke.
I couldn't even believe you. I knew it like 30 minutes in. I was like, what?
And so I was thinking of this as I've dealt with a few cases recently that the exposure could go different ways based on scheduled loss of use or non-schedule loss of use. And, we just got done talking about attachment, like, when you have to attach, when you don't, all this stuff. And the reason why I think it's an important topic for discussion is the premise that I put out is that schedule and non-schedule is compensated fairly, but why is it not? To me, there's like 10 billion reasons why, but like when you first said it's an April Fool's joke, what was your idea of saying, no, that's unfair?
I think the first thing that comes to my mind is just in practice of, doing an exposure analysis in cases when it involves both non-schedule and scheduled sites, of how drastically the numbers can differ, depending on where it lands. I think that in and of itself just sometimes is really glaring to me it's hard sometimes to, if you want to put a stern value on it, you really have to get to the nitty gritty of like, well, are they working? What do we think they're going to end up doing? What's going to be the picture at permanency? Because sometimes I have some cases where, a slew, these are just fake numbers, could be, if he's getting the slew award, it could be $10,000 and that's what they're getting because of the prior payments. But even if this claimant has a 1% loss of wage earning capacity based on his average weekly wage, he could be getting like $50K.
Right.
And you're like, that's a wide range to try and explain to your client. Like, well, it could be this.
Right.
But depending on his work status at permanency, it may also be this. So
I think that's number one with a bullet, right? Is like the exposure differences where like it really separates the adults from the children in this space, right? Like if you can't figure out where the claimant is going to pursue it financially, then you're kind of just stuck reacting to what's going on and not making a plan of attack. Like, so your point is, if a SLU can deduct dollar for dollar credit, but an LWEC can deduct weekly payments or weekly durational awards after you reach 130 weeks post-accident.
Sure. That's another
you could have a whole nother podcast on just that, right?
Yeah,
just the exposure.
That's the other flip side, because I feel like I have a lot of some older claims where the what you touched on, that 15.3W credit is probably really high at this point because of the date of accident and just maybe the designation of awards. But the SLU is also egregiously high. So like if he actually gets the LWEC with the week deduction, it might be less, but the SLUs are skyrocketing. So you don't really know which way they're going to go. And sometimes, and I don't know how you feel about this, and I don't want to get too much on a tangent.
No, that's what this is sometimes the Tangent Fridays.
Sometimes I wonder if I ever want to use that PPD credit under 15.3W as leverage or as like in my back pocket, because I feel like it can change the way the adversary wants to, if they know there's going to be 60 plus or 100 weeks out of that PPD award, are they going to go for the SLUs? You know, like it's really, you don't, so I never know if I should just like hide it until I need it.
Two schools of thought on it, right? Like, because I think it really depends on who the poker player is on the other side of the table, right? Like doing this for years, like you have, like, okay, the person on the other side of the table, like knows what they're doing, is the best in the business, right? Never misses an inch, right? Then it's like, okay, you know what? I've never seen this person before, right? And so I think a lot of times we take that into effect when we are in that negotiation phase, because I don't think it's right to necessarily take the same tact every single time, right? Like for instance, let's say you're dealing with a worthy adversary, a seasoned judge, and then at the last minute you say, oh, by the way, 15.3W, here's like 200 weeks of credit that I'm asking for. I think if you don't provide due notice to a worthy adversary, right, they probably have a very reactive argument to use the safety valve, for example, right? But then, there are times where, you feel like you can get by, and so you will use it in negotiations, right? And so I think that's a good point. But there are some people who take the back pocket approach and it works. So I I think that's one of the more interesting things about negotiation in general is what are you going to choose to show
Right. Yeah. And that's
versus
definitely,
surprise?
that's extremely like over the last few years. That's been something I like handle and try and deal with daily. Like, what am I going to really, and it does, you're right. It comes down to who the adversary is.
Right.
Because there's some adversaries where I'd straight up tell them like, this is accruing right now.
Right.
Right.
And then I feel
So
like
what
that
are we
makes you
doing?
look credible too.
Right. And then I know I think thinking off the top of my head, I know for a fact there's been some cases where I've just raised it at the time that it needs to be addressed.
Sometimes it works.
And sometimes it works.
Yeah. What's interesting about this premise to me is actually I thought of none of those things when I wanted to talk about it today.
Okay.
The thing that I cared about most in terms of like the fairness of the compensation is based on just like the body part versus the body part. Should they be fair, right? Like, so if I like two different examples. One, let's say you have a claimant who has a really bad shoulder injury, right? Like it's just everybody agrees that it's a bad injury.
Right.
But he goes to the doctor and I don't know, he's a former gymnast. And so he's got great range of motion.
Sure.
So he gets nothing.
Then what?
He
Exactly.
gets nothing, even though the injury was, for all intents and purposes, bad.
Yeah.
Right? That claimant is now incentivized to like do something crazy, like raise CRPS.
Sure.
Say like, I have
Psych.
major depressive, exactly, right? It's like, we're teaching people to actually work the system when you create something that's so rules-based on range of motion.
Sure.
Like, it's so that to me is unfair, right? Or the second thing I thought of, you have someone who has a debilitating back injury, right? Like they're working in manual labor and they have a really bad back injury. But they went to college and graduate school, very educated, and they can sit at a desk and lo and behold, like let's just call it a law degree, right? That they've been putting off to the side. They rediscover that passion.
Sure.
Right?
Yeah.
And they say, you know what? I'm going to be a lawyer.
Right.
I have the degree. I passed the bar. I'm going to just sit
Why
at a
don't I do
desk.
this?
Right? And you're making more money. That person is now incentivized, even though they had a bad back injury, they're not going to get anything for it.
Right.
As a permanency award. They might be saying, well, you know what? My shoulder hurts too.
Right. Exactly.
And now they get a slew, even though they've had no wage loss. And I think it's so unfair from that kind of context. Now, obviously, I'm using very hyperbolic scenarios.
Sure.
Right? Find me a claimant that wants to be a lawyer.
I know.
Right? Right? Says a lot about the chosen profession we have. But why? Like, couldn't it be better if everything was on a schedule or everything was on a non-schedule?
Yeah. I also think that's true too. And I also feel like in terms of the deciding factors of, those awards, like obviously the schedules, it's objective medical evidence is what's showing you what that schedule is going to be. But I feel like a lot of the times in practice with like the LWEC awards, a lot of that ends up being subjective based on the claimant's testimony at the trial.
Sure.
Like the medical goes to lengths, but I had a situation where the medicals were pretty light, but based on the claimant's testimony, the judge was like 75% LWEC for a 30-year-old guy.
Oh,
And I was like, that's just not, that doesn't comport and that doesn't seem fair on his end. Honestly, if I was him, I'd be a little offended. Just saying, I'm only 30, I can't do anything. And so I feel like that is also like a weird, unfair factor of like how the statutes and rules are applied and coming to that final result.
Right. I think you're right in the sense that like judges will make those findings because maybe they're thinking, oh, well, I'm just penalizing the employer. Right. I'm just making them pay for this accident that happened 3 years ago. In reality, it's now going to be a decision that this person has only 25% earning capacity.
Right.
What does that do to their actual psyche, their actual, decision to try something new?
Sure.
Right? The fact that, first of all, the fact that age is even considered, right, is a crazy thing too. I mean, we're now it's really tangent, right? But it is a very, very unfair situation because you can try to manipulate the law. I mean, that's essentially what we're here to prevent.
Right.
We find these claimants who manipulate the system, and sometimes the guidelines, while well-intentioned and maybe can provide us with numerical values sometimes create unfair results.
100%.
Thank God for us, though.
I know. Thank God. Thank God we're here to save the day, or at least try to.
All right. So you're up. Third and final one from you.
Third and final. Okay. So in this scenario, or this statement, I guess, failure by the insurance carrier to timely file with the board the pre-hearing conference statement shall result in a waiver of defenses to the claim, including causal relationship and the carrier's right to cross-examine the claimant's doctor.
Oh man, that is so.
That was lengthy and wordy.
Yeah, it's worded in a way where I'm not going to be upset if I get this wrong because, like, if I apply it in a way that I think, but maybe you weren't intending, like, I'm totally fine with it, right? I think the podcast will live on. It won't get shut down if I get this wrong. Okay, so I'm going to say that failure to file. You said failure to file results in a waiver. And it doesn't permit cross-examination.
Yeah, waiver of everything.
Okay, yeah, I'm going to say that is an April Fool's joke.
Correct.
Oh, God. There's so much nuance to
I know,
that.
I know. There is nuance.
Okay, so...
Because sometimes it's tricky. Sometimes you forget.
Because it is a very, very spicy premise there, because if you don't file your PH 16.2 timely, you don't get to present any defenses.
Right.
But you were going... you put a nice little nuance in there about cross-examination because the claimant still has to make out his or her claim.
Right. So yes, that's exactly what the point is. We do lose the right to dispute the issue of causal relationship by presenting our own medical report, but the claimant still has the burden of producing, medical evidence of this causal relationship. Carrier still has the right to cross-examine that doctor on credibility,
which is somehow fair in the sense, okay, you don't file your stuff. Like, yeah, you should have your defenses waived, but sometimes it might even be like taking powers away from someone who just feels comfortable with an IME.
Right.
Like,
yes.
Right.
There's I've in my years in learning more about this field of law, I've been getting more comfortable with not having the IME.
Right.
Sometimes it does not. It's not, the facts don't align with that decision. And I know it could sound scary to a lot of clients, to a lot of employers, but if we don't have our own medical evidence, what's going to happen? And I always remind them, I'm like, we still have the right to cross-examine the treating physician, because I can think of countless times where, we all of our defenses are preserved. We're doing it the right way. We get that IME that concedes causal relationship. And even with cross-examination of the treating doctor can give awful testimony, but that judge sees that IME concession and it's over.
Right.
As opposed to no IME, we don't have anything that's really adverse to us in the file that we produced on our own yet. Let's see what we can get out of this doctor who probably doesn't know the history of this accident.
Right, which is something that you can propose and recommend before you even get to that decision point, right?
Yep.
Like, you have the ability to see the medical record. You can say, like, something doesn't make sense here. Maybe you catch something in the history, right? You can say that this doctor didn't know about prior injuries, and here we have all this stuff,
prior injuries.
right?
Yep.
So, okay, cool premise. Okay, I'm going to end on my last one and talk to you about an employee who was sitting next to his coworker when the coworker sneezed. The coworker stated, "I must have caught what Jenny in HR had." A few days later, the employee's temperature rose to 105, and he informed his boss that he could not work. His claim is compensable, arguing prevalence in the workplace. Is that an April Fool's joke?
The claimant is alleging a compensable claim because he caught what the coworker who sneezed had.
Who caught it from somebody else. Saying that the germs in the workplace are prevalent.
Based on how you're explaining it to me and the facts that you've given me, I'm going to say that's not a compensable claim.
Yeah, so that is an April
Fool's.
And it's so extreme because I've never seen a claim like this come across my desk, right? Like fighting the common cold, like what are we like paying for your Sudafed here, right?
Nasal strips.
But I think the reason why I wanted to talk about it was how the law, I don't want to use the word evolve because that signifies positivity. But the idea that just a mere 5 years ago or so, right, we were dealing with claims where claimants were getting positive COVID tests and saying, well, someone else had a COVID symptom, so it's your fault, employer.
Right. That's why we have it.
And like, I can totally understand the paternalistic system saying, well, someone's got to help these people, right? Like this is this pandemic.
Yeah, it's
right?
obviously something happening in the world.
Right? But thankfully, I mean, first of all, if they did have COVID and in worst cases, long-term or even passing away, this is not a statement saying that nobody should be responsible. This is just a statement saying that you can't prove that you got it from work.
Right.
And so if you take it down to its most specific point, like the common cold, right? How many judges would actually say, yeah, go pay for their Sudafed?
Sure.
Like nobody.
No.
Nobody would do that.
No.
And we lived in a time that was not too long ago where that was happening.
Yeah.
That was the
And
norm.
I feel like it might have been, do you think it was because obviously that time was so unknown and honestly scary? Like no one knew it was happening for a really long time. Do you think it was just I don't know if knee-jerk reaction is the right word, but putting that standard in for the COVID claims, like I feel like there's nothing, we have to try and see how we can help these people because it's a pandemic. I think we don't know what's happening.
Knee-jerk is perfect. I think it was absolutely there because I think, through public policy, through reaction, like you might be deemed to be running afoul of the law, but you're coming to the aid of people who are suffering.
Yeah.
And so there's always that traction that will balance in favor of the employee, just like most of everything in this law. But I just am thankful that we're kind of past that. Like you're not in 2026 getting a claim that you got COVID from your employer.
Right.
And
No, 100%.
Not in 2026. I mean, you might still have open COVID claims. And to those people listening, God bless your hearts. Like, geez, like continue fighting the good fight if you can. But it's just amazing how far we've come through where like fraud was only enacted 30 years ago.
Yeah.
But just 5 years ago, we were letting people just apply the law in nefarious ways to say, okay, now pay for this man's benefits for the rest of his life.
Right.
Right.
It's crazy. Everything changes. Literally anything can happen. That just goes to show that the law just can wake up one morning.
Yeah. But that's why people like us are here. And I think that puts a good bow on it because if you think about it, right, we started this by talking about how I'm so gullible in the outside world. You call people out. You're very straightforward, right? Like you'll tell people the real is the real and you're on their case about it even when it's April 1st, right? So like I guess everyone should just be like you in the sense that think that it's April 1st every day.
Yes.
If you just think that it's April 1st every day, they'll be like you.
Yeah, do your research, do your own research. Don't believe everything you hear.
Right.
And present the facts.
Dig DeSantis versus Pelham Bay Donuts, I think. You'll remember that forever. To prove that you have to be unattached. You have to continue demonstrating attachment if you're unattached at classification.
My favorite.
All right. Well, thank you so much for being here,
having
Alexa.
me.
Just remember that when you're being yourself, that you're like everyone else, and we're reminding you to defend from day one.